Ayes 59, nays 41, abstention 0. For the women of Virginia and the women of America, the resolution has finally passed.
This was the scene at the Virginia State House after lawmakers voted to approve the Equal Rights Amendment. The passage marked a historic moment for the ERA, which was written in 1923 and approved by the House and Senate in the early 70s. Section 1 of the amendment states the following, quote, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex." Virginia is now the 38th state legislature to approve the amendment, which still needs to be signed by Governor Ralph Northam. 38 states needed to approve it for it to become law, but there are legal questions as to whether it actually can. Julie Suk is the Dean for Master's Programs and a professor of sociology at the City University of New York. She also has an upcoming book on the Equal Rights Amendment, and she joins us now. Julie, thanks so much for being here.
Thanks for having me.
So let's start with the history. Tell us about the path that the Equal Rights Amendment has taken and why it began to face opposition.
So the Equal Rights Amendment was written in 1923 and first introduced in Congress then. And at the time, it was supported by some, but not all women who were part of the suffrage movement. And at the time, there were concerns that if equal rights meant identical treatment for men and women under all circumstances, that sometimes that might not be to the benefit of working women in the judicial and legal context in which they existed at the time. So the Equal Rights Amendment didn't really get off the ground until the 1970s, and it was certainly boosted by the civil rights movement of the 1960s.
Well, if it becomes part of the Constitution, what would the ERA actually do?
Well, first and foremost, it would really recognize over 100 years of work by women lawmakers, women judges, women lawyers, women activists, and turn them into constitution makers and founding mothers, and really solidify this nation's commitment to sex equality as a foundational principle. And in so doing, it would really overcome some of the blind spots of the Equal Protection Clause and existing parts of the Constitution that have insufficiently responded to the needs of women.
So 3 states have approved the ERA after the 1982 deadline: Nevada, Illinois, and now Virginia, pending Governor Northam's signature. Why do you believe there's been this new push to get the ERA ratified?
So the new push really began in January of 2017 on the heels of the Women's March. I think when millions of women across the country and really around the world marched for women's rights, they drew attention to the fact that law is not doing enough for gender equality. And when Illinois ratified in 2018, that was right in the thick of the Me Too moment. There was new attention drawn to issues of sexual violence and sexual harassment. And then in Virginia, I think there's been a real groundswell with women in the state legislature, and particularly in all 3 states, women of color in state legislatures who have really been leading the effort to get ratification done.
So the Justice Department's Office of Legal Counsel, as you know, released an opinion on the ERA, noting the 1982 deadline to ratify the measure. And it says, quote, "We conclude that Congress had the constitutional authority to impose a deadline on the ratification of the ERA. And because that deadline has expired, the ERA resolution is no longer pending before the states." Does the Justice Department have the authority to issue that kind of statement?
Well, the Justice Department has the authority to respond to a question by the National Archivist, which is what it did in that memorandum. But what the Justice Department says there doesn't bind Congress and is actually incorrect about the law. Congress has the authority to impose deadlines, but that same authority gives Congress the power to extend deadlines and to remove deadlines. And there are bills in both houses of Congress right now that would do just that, remove the deadline on ratification.
Well, we mentioned the 38 states that voted to approve the ERA. 5 states, Nebraska, South Dakota, Kentucky, Tennessee, and Idaho, have since voted to rescind or withdraw their ratification. Is that allowed under the Constitution?
The Constitution doesn't say anything about it, but there were states that tried to rescind their ratifications of the 14th Amendment and the 15th Amendment, which guaranteed equal protection of the laws after the Civil War and African Americans the right to vote. And those rescissions were not recognized by Congress. So it's really up to Congress to decide whether to recognize those rescissions of the ERA. And since they did not recognize those rescissions with regard to the 14th and 15th Amendments, I don't think that Congress will recognize the rescissions of the states that rescinded the ERA.
So you mentioned the Archivist of the United States, a federal official. Can you just elaborate on the significant role that that he could play in terms of constitutional amendments?
Well, the Constitution doesn't say anything about that. The National Archivist has a role under a statute that says the archivist should record the ratifications and then publish the amendment. But that doesn't make the amendment law. What makes the amendment law is Congress proposing it to the states and the states ratifying it. 3/4 of the states need to do so, and 3/4 of the states have done so. And now we just have to address the question of the validity of the deadline.
All right, we're going to continue to watch this. Julie Suk. Julie, thank you very much for your insight.
Thank you.